Good afternoon. It is my privilege and pleasure to welcome you to the University of Trento, and in particular to the law school, and in particular to this international workshop, which is about to start and will continue until tomorrow at about noon. So, welcome for those of you who came from a short distance, and also for those of you who came from a long distance, and in particular because you took such a long way to come and share your knowledge and your insight about the topics that we are all interested in. I realize that Trento is not so easy to reach, and so I'm particularly thankful. I didn't do anything. So I say this because we have made a number of rehearsals about how much light and what light we want, and so it just happened to be on. So, do you think this will affect your slides? No? Okay. So thank you again, and it will be, I think, quite interesting because although you have already a presentation on the program, we are from fairly different backgrounds and we have different interests and experiences, although all of us share an interest in the legal method, in the legal approach to the problems that will be dealt with today and tomorrow morning. Now, the topic, as you know, is a debate on the Uniform Civil Code in India. And then there is a question, new perspectives on constitutional secularism in India and personal laws regimes in Asia. Now, of course, in Asia is a little bit too ambitious, of course. But in general, I would say that the topic of our seminar is indeed crucial and quite challenging. And the seminar, consequently, appears to be very interesting and promising, both from the point of view of the starting point and from the point of view of the point of arrival. Now, geographically, the starting point, of course, is India, and the point of arrival, as I said, is not really Asia, as India is already part of Asia. But we are going to focus on South Asia, in particular Bangladesh and Pakistan, and Southeast Asia, in particular Malaysia and Singapore. So today we depart India, and tomorrow we get to South Asia and Southeast Asia. Now, this from the geographical point of view, but culturally and legally, needless to say, both the starting point and the point of arrival are in fact by themselves a subcontinental scenario whose main features are to be read more as a wide or as a collection of wide and deep diversities than as a scenario with shared characteristics, although such a rich variety is still to be explored within a common framework of Asian culture and in particular of Asian constitutional culture. Now, in between the point of departure and the point of arrival, geographically, culturally, and legally, there is a huge space, partly effective and partly hypothetical, yet to be tested, a huge space of circulation of constitutional models, ideas, normative and judicial solutions, as it normally happens in other regional parts of the world, and as it is commonly analyzed by a growing scientific literature in comparing constitutional law in Asia. And I'm personally glad, and I would say more than glad, that at least more recently there is a growing number of contributions to such a literature arriving also from Italy. Of course, we have here Domenico Francavilla, who is one of the pillars in the Italian scholarship on Asia and in particular on India. We may have the privilege of having the visit of Professor Gabriele Crespi Reghizzi, who is I would say, the father of studies, of comparative studies in Indian and Asian law in general in Italy, and then, of course, Professor Amirante, who will join us tonight, Chiara Lappi, who is here present and who is representing, let's say, if you allow me, the younger generation dealing with Indian law in particular. There is, as I said, a growing literature on comparative constitutional law in Asia, and I still think that a volume which has been which is very important, and which is, I would say, a must in such an area, is a book called Comparative Constitutionalism in South Asia, published by Oxford University Press in 2013, and edited by 3 scholars, and one of them, Arun Tiruvegada, who is here with us today. So we have, let's say, a number of interesting and, as I said, promising coordinates to start our seminar today. Now, the starting point, again, is India, and in particular, a renewed interest in the debate for the adoption of a uniform civil code in India, as already stated in Article 44 of the Constitution, where it says the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Now, I decided to read the text of Article 44, which all of you know, but I think it is important to stress the state shall endeavor. It doesn't say more than that, and in fact we may say that the state has been endeavoring to, with a different degree, in different periods of history, and perhaps it is endeavoring right now. But the point is that it is a very unusual normative statement. It is, let's say, an obligation to do something. It is not an obligation to achieve a result. We will say una prestazione di mezzi, non di risultato. Sorry for the Italian, but this is technical Italian language. And so, as I said, this might be interesting because it might suggest that other provisions may be read also in the light of the commitment to achieve rather than the obligation to the commitment to achieve rather than a commitment to achieve. Now, the system presently in force, which is alternative to a uniform civil code, is mainly based on religious personal laws. Not entirely based, but mainly based, at least I think, as far as I know, from the point of view of practice. Now, on such ground, the adoption of a uniform civil code would be connected also to the preamble of the Constitution, where it is stated, and in spite of the fact that it is a preamble, it is, I would say, normatively stated that India is a secular state. So 2 provisions, 2 statements which are quite compelling, and of course they must be read in context. The transition, then, if it will ever take place, is, I would say, at least in my personal perception, an authentic challenge. As is the case every time the concept of uniformity is applied to the Indian subcontinent, where diversity is very much rooted in the very genetic code of culture and society. And uniformity consequently appears to be forced to rely on some imposition from above, and to be inevitably dependent on the receptivity, not only by the people at large, but by a number of qualified stakeholders whose influence has proved to be quite powerful and effective since the adoption of the Constitution. So it is easy to anticipate that any transition, I repeat, if it will ever take place in this area, will be hard to manage. And whatever the legislative outcome may eventually turn out to be, the interpretation by the authority of the Supreme Court, and we all know that the Indian Supreme Court is always to be taken for granted as far as the fact that they will adjudicate is concerned. So any outcome is going to go through the interpretation by the Supreme Court. And the case law by the Supreme Court, once again, will prove to be necessary in order to settle the new balance between the meaning of constitutional secularism, the content of religious pluralism, the margins of operation of legal pluralism based on religious personal laws. So the force of religious pluralism and freedom of religion of minorities in India may greatly affect the religious component of the very concept of an Indian nation and of Indian nationalism as presently represented in the political and electoral context. In fact, the boundaries, the very concept of constitutional secularism in India may find a different shape than in other regions of the world. Now, let me add that the point of arrival, as I indicated earlier, is the potential impact of the current debate in India on other parts of South Asia and Southeast Asia, considering, among other historical factors, different cultural and national variables, the respective role of Buddhism and Islam, in particular in South Asia and in Southeast Asia, respectively, being crucial factors in a context that is mainly not theocratical nor secular, but rather confessional, at least from a European perspective, with varying degrees of tolerance towards religious minorities, although religiously based legal pluralism is fairly present there to a large extent. So this seminar might offer also the opportunity to reconsider general categories of constitutional law and comparative models in the light of several relevant experiences and trends, including also perspectives coming or drawn on mainly Islamic context. So a very rich perspective of analysis for our 2 days, for our workshop. And I would like again to thank you for participating, thanking you for your attention. And now we shall really enter into the topic by giving the word to Professor Arun Tiruvengadam, which I'll do not after having said, just for the sake of organizing our proceedings, that we are going to have, I suppose, the 2 presentations before approximately 4:30, and then we have a short break, coffee break. Coffee will be offered just upstairs, and then we, after 15-20 minutes, we'll start again, and we have a discussant, Chiara Lapi, and then we have free discussion until 8:30, and of course, without marginalizing the role of the presenters, I all feel the discussion is almost as important as the presentation of papers by the main speakers. So I think that we are going to be quite busy until 8:30 tonight. And then, of course, 6:30 tonight. And then, of course, tomorrow is another story and also another chair. And I would like to take the opportunity of thanking Professor Marco Ventura, who is here today as well, for chairing the workshop tomorrow morning. So without any further ado, Arun, you have the floor, and thank you very much.
Thank you, Professor Toniati. I'm delighted to be here. It's my second time in Trento after a gap of 4 years. I should say that my first visit here was very fruitful for me intellectually. I came here to teach part of a course on Introduction to Asia, and I had to teach a short module on Introduction to South Asia. And as anybody who has done these kind of courses knows the challenges involved. But I had a wonderful group of students, a couple of whom are still in touch with me, and they challenged and pushed me in ways which I think really helped me to think about the subjects that I talk about, and also look at issues afresh. I say that because one could think that the debate in India about the Uniform Civil Code is a very particular debate. It has a very long history, and at one level it seems like a very internal debate to India. So I think a legitimate question is, why should a group of people outside of India be that interested in the minute details of a debate which is legal, political, sociological, and has other complexities in it. But as Professor Tanyati was very generous in acknowledging work that I've done before, I should say, and this is important, that my background is of a constitutional lawyer and a comparative constitutional lawyer. The same topic is studied by many groups of scholars. People who focus on the religious aspects of it might see it quite differently. And I'm not suggesting that any one way is a better way to see it. My background is of a public lawyer, and my natural inclination is to look at the politics of ideas and what goes. So that dictates somehow the way I see it. So I think that caveat is important, because some people may be a bit puzzled by my take on this subject, which really derives from a very particular viewpoint. I shall say a little bit later about how do we study issues like this, and why there's great value, not just in comparative perspectives, of which I am personally quite convinced and I've benefited from, but of interdisciplinary perspectives. And that these are not, they have aspects of the law involved, but certainly lawyers do not have a monopoly over this, and should not, I think, have the final say on these issues. These are matters that affect all people, citizens and non-citizens alike. And the challenge of our times, I think, is to be able to find ways to engage with these issues from whichever perspectives we come from. So, having said a couple of caveats, let me quickly get into the topic. I should apologize and say also, when Professor Tonyati asked me about this 6 months ago, I wasn't entirely sure that this was a very an area that I was comfortable talking about. It's not an area that I've written about in the past, though I've started doing some research on it. But as it happens, and perhaps Professor Tonyati should be lauded for his prescience, this issue has become extremely significant. There was a sort of consensus among scholars that the Uniform Civil Code is, as a European scholar, Tanya Höklotz, calls it a dead letter. And for a long while, the consensus was that this was not going to be revived. But in the past few months, and my presentation will focus a little bit on that, it has become extremely topical. So this morning, as I was checking newspapers in India, there are a couple of very good op-eds about the forthcoming litigation in the Supreme Court and what people think about the discourse around Uniform Civil Code. So this is a very timely topic. I haven't got my ideas around it in a very coherent form. They are very scattered. But I know this from my previous time in Trento, that the discussion is very much valued, as Professor Tanyati was saying, and I present this to you as very much work in progress, things that I'm still working out for myself, and I have no doubt that discussing it with a comparative audience will help me see things that I'm not paying enough attention to for now. So that's the last caveat, that this is completely freshly cooked to the extent that the ingredients are perhaps undercooked, and all of them don't go very well together. But at the very least, it should set the stage for a stimulating discussion, and I see my goal as that. So a little bit about the title, Multitudes and Contradictions, the Uniform Civil Code and Personal Laws in India. The title is a nod to Walt Whitman's line, which is very famous from a very long poem called Song for Myself, which people don't read the whole poem. They usually just talk about this one line where he says, if I contradict myself, so what? I am large and I contain multitudes. And of course, he's talking about the many identities that a single person can inhabit. In this case, I'm talking about a very large nation and how the Uniform Civil Code discourse helps us understand many of the contradictions that the legal, political, and constitutional system of India is confronting with. The subtitle says Contemporary, Historical, and Constitutional Perspectives, and maybe I'll just map this. I doubt very much if I can complete this in the allocated time, but I put it up on the slides so that if in discussion anyone wants to talk about this, we can come back to it. But I just thought this is what I have in mind. I'll start with the contemporary context, and perhaps because not many of you have been in India recently, that needs some fleshing out about why, as I said earlier, this issue has been revived, and what's the context which explains why it has been revived. I know there are many people in the room who have deep familiarity with India, and I don't want to make things too basic for them. At the same time, I recognize there are students here who may be coming to India afresh. So my difficulty is in trying to strike that balance, and I'm not sure I will be able to do it here, but perhaps in question answer we can get into that. So the first part is the contemporary context, and that's what I'll be talking about in some detail. The historical context is very important, and scholars who focus on that know that quite well. I'm just going to map out some broad sketches of that period. This is the pre-colonial period and the period of British colonialism, which had a huge impact on the constitutional post-independence regime, which was constructed in response to that. And that's the third aspect, what I call the constitutional context, which is from 1947 till now. So I've mentioned a few things. I'll probably come back to them. I won't go into them here. This is the reference to the multitudes. And I think even many Indians are sometimes struck by the size and the diversity which is involved. So Professor Tonyati talked about diversities, but I find that I myself am occasionally surprised by how little I know of these diversities. And I just thought a snapshot view would be useful. So I take as a framework the historian Ramchandra Guha, who said that Indians have social contestations along 5 markers of identity: religion, caste, language, gender, and class. I would suggest that all of them, including class, which I don't focus on very much, have something to do with the Uniform Civil Code debate. And they're relevant and to be minded. So just in terms of population, and I'm relying on the 2011 census, this is quite important because the census itself is a colonial insertion into India. So Indians didn't define themselves by categories of the census. The first census conducted in the late 19th century actually had a profound impact on how Indians perceived themselves and saw each other. So, for instance, the majority of Indians who now self-describe as Hindus probably didn't do that in the 19th century. You didn't think of yourself as Hindu. You thought of yourself as following a particular deity or being from a particular caste community and a particular region. These were far more important than some broad identity of being Hindu, which would unite people across the country. This is important because the discourse around national unity and nationalism today is very much of the Hindu right, which is relatively recent in terms of gaining influence in government. And I mentioned that for that reason. But having said that, if you accept that, then you find that of the 1,200 million Indians, you divide it by religion, you come to Hindus, Muslims, and Christians. I've just set out the figures there. It's important, like I said, the 966 million people who consider themselves Hindu are further divided by caste, and the caste categories are also extremely detailed. It's very difficult for sociologists of caste to actually give you a good answer of how many castes are there in India now, and how do people identify with them. These are also fluctuating categories, which are very hard to pin down in some ways. There are legal reasons. The Constitution actually, since people get benefits and privileges based on caste, there is a legal obligation to quantify them and have a sense of them. But it's incredibly difficult to do it. There's an ongoing debate about the Backward Classes Commission, which is supposed to numerically quantify people who fall within the category of backward classes because they get government benefits of that. And it's very, very difficult to do that. The linguistic issue is also extremely important. Many Indians would identify perhaps more by language and by region than by religion. And the diversity of languages is also fairly critical to recognize. And that's why the numbers about the number of languages, so 30 languages have more than 1 million speakers, about 122 languages have more than 10,000 people who speak that language. The Constitution officially recognizes 22 in the 8th schedule, but this does not have legal implications in terms of making information available in translations. The 8th schedule has more of a symbolic effect than anything else. The issue of gender is extremely important because when it comes to the Uniform Civil Code, at various points of time, people have asserted that gender equality is a reason for having Uniform Civil Code. That reason has not always been the most prominent reason. Sometimes it's been in the background. Some people think of that as an alibi for other agendas. But the gender, too, is quite significant and needs to be mapped. Okay, so the first context, and I'll spend a little bit of time on that contemporary context. So one of the themes that I'm going to emphasize is there tends to be, even within law, people who do Uniform Civil Code tend to be from family law, whereas that's not the only lens under which you understand what's going on. So one needs to take a broader context. Professor Amirante will join us tomorrow, and his work on federalism is very important to understand even the Uniform Civil Code discourse. And these are not things that people automatically connect. But I'm increasingly of the view that you have to understand these dimensions, these other dimensions also become very important. So the political context, which as I said, that's my natural tendency is to focus on that. And I think it's not a matter of debate that political context is the reason behind the revival of the Uniform Civil Code discourse. So just some numbers of what happened in 2014 when Narendra Modi became the Prime Minister of India, a seismic political event. The last time a single party had a majority in Parliament was in 1984. So this is after 3 decades. India had either actual or virtual coalition governments since 1989 till 2014. So as the numbers show, the BJP alone won 282 seats out of the 543 seats in the lower house of Parliament. It was in a coalition. That coalition has 336 seats in the lower house, which gives it a fairly controlling majority in that. Important to note, and this is relevant because this idea is India becoming a Hindu theocracy. Narendra Modi may have pulled off one of the most amazing victories in parliamentary elections in India, but he did so with only 31.34% of the votes. So this is part of constitutional design. India follows the first past the post system. We have a very fragmented political party distribution, and that sort of accounts for that as well. So in the lower house of Parliament, they have a majority. We are a federal country, and state elections are important for peopling the upper house of Parliament, where the BJP, as of now, out of the 250 seats, controls only 74. So it doesn't have a controlling majority. But since 2014, they have won state elections consistently and at an extraordinary rate. So as of March 2017, the BJP, the NDA, which is the coalition that the BJP is part of, is in power in 16 out of 29 states. What this will lead to is that they will, in the foreseeable future, get a majority in the upper house of parliament as well, right? If things go as they're going. And that leads to then parliament being able to push through a law on this subject. Very brief overview, as those of you who've been following the news from India, this is not new. 2014 also marks a period, depending on how you see it, either a period of crisis for constitutionalism or a new phase of constitutionalism where whatever had been seen for the last 25 years has changed. And you can see this across many lines. So Professor Tonyati talked about the judiciary in India, and you can take it for granted that they will issue judgments. They've suddenly become a little skittish. They've rediscovered the virtues of judicial restraint after having completely forgotten what that meant for 25 years. But perhaps it's because there is now a powerful government in Parliament. The first constitutional amendment that the Modi government moved was to control judicial appointments. And that's a skirmish which is ongoing. But you can see it's a bit like a ballet dance, or maybe I should use an Indian dance and say kuchipudi, where the actors are nimbly prancing around and not always sure what's going to happen from the other party. There have been secularism concerns. This is something Narendra Modi was a controversial candidate for Prime Minister. Many people think he should be charged for genocide for the killings of Muslims in 2002 in Gujarat when he was the state chief minister. Those concerns were sought to be allayed by people who said that Modi ran his election pretty much on a developmental agenda and that he wouldn't go for the old Hindu right pet issues. As it turns out, that was misplaced, because many of the old issues have come back. Cow slaughter, which is, again, a constitutional provision, whether it's a mandate or not is debatable, is something that has become a very important legal issue as well, as many states have passed beef ban laws, as they are colloquially referred to. There have been an increase in violent acts against minorities, religious minorities, including Christians and Muslims, and there's been a curtailing of civil liberties across the board. But this is not particularly new. We live in the times of Erdogan, Duterte, Trump, Viktor Orban. So this is something we know has been happening around the world. There are some similarities in why that has happened. I mean, Modi's rise has something to do with the fact that for 10 years before then, we had a government which was sometimes lauded for its progressive policies, but was almost universally acknowledged for doing a bad job on communicating its ideas and for being paralyzed at many times. So the yearning for a strong man, someone who can get things done, it seems like a universal credo in our times. Okay, so specifically, what has that got to do with the Uniform Civil Code? Again, not always clear. In its manifesto for the 2014 elections, the BJP had put in its old idea of a Uniform Civil Code, but if you notice, it was at page 49 of its 52-page manifesto. It was sort of there, but nobody really took it seriously. It says things like BJP believes there cannot be gender equality till such time India adopts a Uniform Civil Code which protects the rights of all women, and the BJP reiterates it. So it's interesting that the BJP used gender equality as the reason for advancing a Uniform Civil Code. The reasons offered of late have been very, very different. Many people see this as a direct attack on Muslims in India and Muslim culture. There's been talk of national unity. All that was not mentioned in the manifesto, where the language was somewhat guarded and carefully chosen. But again, people didn't expect it to, by itself, take on prominence. The Law Commission of India, which is the premier body for initiating law reform, it's usually headed by a former Supreme Court judge, and it's had a long history. This is the 21st Law Commission. There are several hundred reports that the Law Commission has issued. Sometimes they become salient and become the basis for law, but very often they just lie without being attended to. Nevertheless, it is the most important law reform body. And the Law Commission in September 2015, there was a change of guard. So the Law Commission, the head of the Law Commission was a former High Court judge appointed by the previous government. And in September 2015, it was reconstituted with Justice Balbir Chauhan, who was appointed as its new chairperson. In October 2016, the Law Commission issued, I think it's safe to say, a strange document. It said that it wanted to invite public responses on the question of a uniform civil code. It's a 5-page document with a 4-page questionnaire. It has some very basic questions on what should, I say basic because they're also terribly disturbing questions in terms of what they reveal of the mindset behind it. So I teach in a LLM program in India. If my students had developed a questionnaire of that sort to do a survey, they would all get a failing grade. So it's a matter of concern that the premier law reform body comes up with that kind of a questionnaire. And again, to show you how they invited response within, that's not 15 days, within 45 days. And you wonder that this is an issue which has been a legal issue of importance in India for well over 70 years, and the Law Commission wanted responses within 45 days. They subsequently extended it by another 30 days. But that is something which people saw as a signal that this is back on the agenda and things will go on. Again, not to put it entirely on the BJP's door, there are, of course, in India, the Supreme Court has always been an actor, especially on the Uniform Civil Code. And in this case, there's also individual citizens who are affected. So an unusual woman, Shiara Banu, was a Muslim woman from Allahabad, I think, in the center of India, filed a petition because she was instantaneously divorced by her husband. It's interesting that she challenged the practice of instantaneous triple talaq, not the practice of triple talaq as a whole, and that was her claim. And in her case, it's very clear that this was an extreme case, and she'd suffered a lot, but she herself filed the petition. In India, it's rare for people of minority communities, particularly to challenge the community law, but in this case, Ms. Banu's case is also a trigger. In February 2017, the Supreme Court said that it would take this up, and on May 11th, they will begin hearing. There are several Constitution Bench issues pending before the court, but the court has picked 3, and of these, the most important seems to be the triple talaq case. So the judiciary has also now decided that this issue will be on it, though the current Chief Justice, who will retire by August, so if he sits on this bench, we may have a decision as early as August, has already made clear that he is not going to rule on the question of the Uniform Civil Code. So he said, this is only about triple talaq. There are 3 issues, nikah halal, triple talaq, and polygamy. And he said these will not go to the question of a Uniform Civil Code because that is for the legislature to handle. Nevertheless, you can be sure that the petitioners and respondents in their arguments will link it up to the broader question of a Uniform Civil Code and how one should deal with it. So that's a long way of sort of explaining why this issue is very much now on the agenda, potentially of the legislature. If the Law Commission does come up with a report, that could become the basis of a parliamentary law. As I've explained, the BJP has the numbers to be able to push that law forward. Whether it makes political sense, whether they will go ahead with it is a different matter. And the court has also picked this issue up and put it on the. Now, what's happening there is the court trying to curry favor with the government and get some leeway because it's locked in this conflict over appointments. And is this some way of saying, okay, you give us a little and we'll give you some? It's not clear what's sort of happening. Okay, 10 more minutes, so I'll breeze through this part, the historical context, which I suspect others will address a bit more carefully. All I want to point out here is that it's not always clear. I mean, there is a standard story to say that the British came up with, allowed personal laws to exist because they were trying to divide and rule Indians. And there's a standard sort of nationalist version of that, and personal laws are bad because the British used it to divide the subject population. I think many scholars have pointed out that that's a very crude view, that the reality was much more complex. The East India Company and the period of British Raj that followed were fairly complex phenomena. They may well have been people who took that line, but there were others who were of a different motivation. And it's important to sort of separate out different phases that come there. So in the colonial period, I've sort of demarcated the East India Company phase from 1757 to 1857 and the British Raj phase from 1857 or 58 to 1947 when India was ruled from London directly as opposed to indirectly under the East India Company. So the Hastings Plan is important because this was a plan. Warren Hastings himself was a Sanskrit scholar who taught himself Sanskrit. William Jones and other Orientalists initially were very much of this mindset of preserving civilization that they came in. So they were far more sympathetic to what they found when they came to India. So to tar them as people just interested in concentrating power would be unfair and intellectually disingenuous. From 1882 onwards, when you started getting people like Bentinck and Dalhousie, who were liberal utilitarians and were much more committed to the idea of individualism and this idea of legal universalism or legal monism. So I should say that I couldn't be here last year for the conference in Trento on legal monism versus legal universalism, legal pluralism, sorry. But I did watch in preparation for this the videos of that, and if any of you are interested in this issue, I would strongly recommend them. I think there's a very nice comparative setting up by Professor Ferrari, who talks about how personal laws were actually commonplace in Europe as well till the 15th and 16th century, and then you get a process of what he calls centralization and secularization, which leads to what you have today, where in his definition, no European state has a personal law regime. In India, you can see that during the colonial period, there was a similar sort of impulse. This is partly because the East India Company and the British Empire had to centralize and also secularize, which they did to a certain extent, though the motivations varied between different actors at different periods of time. Much of what I'm drawing upon here is in an excellent book chapter by Lloyd and Susan Rudolph, written in 2001 in a book edited by Gerald Larson, where they provide a snapshot view of this entire period. And they describe this period of Congress nationalism. This is when the nationalist movement is in its infancy. It's developing its vision for an independent India. And very early on, they developed an allergy for strategies that the British had followed, including, for instance, the idea of a separate electorate. So in the late colonial period, Indians were allowed to have separate electorates based on religion. And it's debatable. I mean, the nationalist movement saw this as very much part of divide and rule, but a more dispassionate view could see that as an interesting mechanism to try and preserve for particular communities particular privileges. Right? I should say that there's a tendency also when we look at legal monism and legal pluralism to sort of valorize legal pluralism and see that as a great value. One must remember that these are ideas which have sometimes had complex histories. So even if one normatively believes that legal pluralism is a good thing and a good way to go, one must recognize there are historical instances where legal pluralism was used very much for non-progressive ends. And there is nothing about monism or pluralism by itself which can provide always normatively desirable results. And I think the colonial experience in India is an example of that at various points of time. Okay, so the last part, and I will wrap up in another 5 minutes.
No, your watch is slow. You have 10 minutes.
Okay, great. So then I shall probably go through this. I'm sorry for rushing through it a little bit, but if there are particular details that I've mentioned that you found interesting, please probe me further later in our discussion period. But the post-independence period, this is the one that I'm going to be particularly sketchy. In the making of the Constitution, to follow up from the previous point, the nationalist movement was very much against giving legislative privileges to religious minorities. And so they abolished certain practices followed during the colonial period, and they kept some others or modified them. Right? And the Constitution of India represents that modification. There's a debate on whether the Constitution of India represents a liberal view because it seems to recognize group rights in certain contexts. It also guarantees individual rights. It protects cultural and educational rights of religious minorities. It provides for the former untouchables. It abolishes the practice of untouchability for people who were disadvantaged because of caste. There are all kinds of benefits, including legislative privileges. So separate electorates were abolished. Those applied for religious minorities. But in the post-independence mechanism, you had legislative quotas for people who had suffered on account of caste. So religion didn't allow you to have legislative privileges anymore, but caste did. So why did they substitute it? There's a long, complicated sort of history. Very quick reference for anyone interested in that very interesting history, and to sort of determine whether the Indian legal order can be called a liberal order or not. What kind of liberalism does it reflect? Rochna Bajpai has an excellent book published in 2011 called Debating Difference, which maps a lot of that terrain. Okay, so Article 44, since that's important, it was initially championed in the Constituent Assembly by liberals like Meenu Masani and two prominent Indian women. I mean, there's a reason why we don't call the framers of the Indian Constitution the founding fathers, because there were several women involved, and so we had founding mothers as well. And Amrit Kaur and Hansa Mehta were both privileged women who came from privilege and were liberal in their outlook, and they had the concerns that the personal law system would be inimical to the interests of women. So they championed the idea of a uniform civil code. But by then, you have to remember the historical context. Partition had happened. A number of Muslims who lived in the subcontinent had gone, and there were others who stayed back. People like Nehru were not willing to give Muslims who stayed back separate electorates, but they recognized that there was a huge psychological blow and that they would be subject to discrimination. So the unofficial compromise that they came to was that Muslims who stayed in India, and not just Muslims but other religious minorities, but primarily Muslims, would be allowed the privilege of having their personal laws. So the Congress oligarchy, as Granville Austin calls the people who controlled the Constituent Assembly, decided that they would accept the proposition of the liberals, but they would put them in the judicially unenforceable Part 4 of the Constitution, where there would be a directive principle. So when Professor Thonyati points out the language of 44 and how it's a bit ambiguous, one has to remember it is ambiguous, and its status becomes even more interesting when one thinks of the fact that there were several provisions in the Indian Constitution which had time limits. Whereas this, they leave it amorphous and vague, and that's why scholars have called this clearly the work of compromise. And there are many strategies by which framers of constitutions either defer or delay decision making to avoid the negotiations breaking down. And 44 is seen as one of those provisions. In the early 50s, the Nehru government, which was very focused on a particular version of nationalism, and it's important. In India today, there's a huge debate about nationalism, and it's seen as a Hindu right debate, where you have to prove, and as the former chairman of the Law Commission, gave a powerful speech 3 days ago, where he said, we are now constantly being told what we can eat, what we can watch, what we can say, and this is really deeply against the constitutional culture that was put in place in 1950. And in that sense, that is true, but one has to remember that Nehru too was a nationalist. He was a modernist, secular nationalist who was also trying to put forth a certain vision of nationalism. And of that nationalism, the Uniform Civil Code was an integral part. So again, this just going back to that main theme of the proponents of the Uniform Civil Code have been interesting people at different points of time, and to ask someone what is your position on the Uniform Civil Code is actually not revealing very much, because a range of actors with a range of political and social beliefs have championed the cause of the Uniform Civil Code. So as the Rudolphs argue, you should see it as a process rather than an outcome. And watching and studying that process carefully tells you a lot about the kind of churning that's happening in a particular legal and political order. So post-1950, the Nehru government pushed through the Hindu Code Bill, and the idea there, and some people see this as part of the Uniform Civil Code. Nehru said, if we are going to reform the religious laws of people, to show the minorities that we come in good faith, we start with the majority religion. And that is Hinduism, and so let's reform Hinduism, bring it along modern scientific principles. He faced great opposition, including from the president, the first president, Rajendra Prasad, and as those of you who know this are aware, Ambedkar, the chairperson of the drafting committee, quit Nehru's cabinet on the ground that the Hindu Code was not being pushed through, and it didn't come through in 1951. It came through in a series of smaller laws in the middle 1950s. It's arguable that a lot of the initial impact was diluted. Ambedkar didn't live to see all the various laws, but would probably have been quite unhappy with what came out, and they were again a process, they were a product of negotiation and compromise. So women's groups, again, another actor whose position has changed over a period of time. Initially were for the Uniform Civil Code. As I mentioned, even in the Constituent Assembly, there were women who championed the idea of the Uniform Civil Code. But by the 70s onwards, the women's movement also sort of backtracked and began to have doubts about whether a Uniform Civil Code was the way to go forward. As it evolved, a number of women's groups have said that the initiative should come from women within religious communities being involved in the process, and it should be more of an internal to religion process. Yet other groups have pointed out that may sound good and may be theoretically and normatively desirable, but at a practical level will never happen, because in every religious group, the people who control what reform can happen will tend to be conservative, will tend to be status quoist. Liberal voices in religious groups are usually in the minority. It's rare for them to be on the ascendancy, and so it doesn't really amount to a very practical solution sort of going forward. So from the 80s onwards, it's really been the judiciary which has taken the cause of the Uniform Civil Code. Again, I should say it's done so sporadically. There's a lot of discussion of the Shabano case or the Daniel Latifi case, and those of you who are familiar with the case law can point to any number of decisions. But you have to remember that the Indian Supreme Court today is a 31-member body. It doesn't sit en banc. At any given point of time when you go to the Supreme Court, there are 12 or 13 benches which are working, and they all speak in different voices. It's not unusual for on a single day for two benches to come up with opposing rulings. That may happen by accident, but even by deliberate design, sometimes it plays out. So to give you an example from a completely different context, if you think about LGBT rights in India, a two-judge bench of the Supreme Court overturned a High Court decision which had struck down India's anti-sodomy law. And the Supreme Court said in the Kaushal case that it was for Parliament to decide, and the courts couldn't step in that. So as a result, same-sex sexual relations in India are still officially a crime. Another bench of the Supreme Court, in a case decided a little later, held that transgendered persons have a right to identity and have a right to their rights being respected. So you have this anomalous situation where a conservative bench struck down rights for LGB populations, but the T population gets a progressive decision from another bench. Right? So you work in a system which has these many contradictions, and that's also very much part of an institutional design question. So if you point to a decision of the Supreme Court in a particular case, then one has to look at it and say that's 2 judges or 3 judges. That doesn't represent the view of the entire court. The triple talaq case actually represents an institutional mechanism by which the court tries to be consistent. So when it says a constitution bench is going to sit, it means 5 judges are going to sit and resolve these contradictions, sometimes of the court's own precedent. And this is an attempt to try and sort of do that, which is why the case then gains significance. I'll just end this bit with the Rudolph's, I think, very insightful comment made 16 years ago, but applies absolutely to today's context, where they identify different understandings of the Uniform Civil Code. So the British had a certain purpose. The early nationalists, including Nehru and Patel, had a certain view of why they wanted a uniform civil code. Civil rights activists, and so the British and the early nationalists were for the uniform civil code. Civil rights activists usually will focus on, like in the Banu case, an individual woman or an individual of a sect or group which is within a minority religion being discriminated against by others. So the Ahmadiyyas are an example within Islam. And so they tend to be suspicious of this idea of a uniform civil code because it will be regressive and will curtail rights. Religious minorities, for good reason perhaps, are suspicious of the uniform civil code because they see this as an attempt to curtail the freedoms that they enjoy. And the Hindu right, of course, has a particular version of the Hindu. And there are people who very openly said, yes, India needs a uniform civil code, and that uniform civil code will be a Hindu civil code. So there's a reason why people who are from the BJP look at Israel, for instance, and in some ways Israel represents what they want to be sort of secular, but with one state religion, which is officially out there. Okay, so now to sum up, and I'm sure Professor Tonyati will now remind me of the time. The last 2 slides just talk about some themes to sort of recapitulate for in general. So we know that the debate about these issues oscillates between how much value you assign to freedom or to equality. Likewise, individual and collective rights. We've talked about legal pluralism and legal monism. What the Indian experience shows you is that another fairly important factor, especially in relatively younger countries, is how ideas of nationalism feed into these questions. So legal monism was seen at the time of the drafting of the Constitution and the early years as a value, and you could argue that people who had liberal and nationalist ideas of equal uniform citizenship favored such ideas, and perhaps they were necessary to some extent. But as the post-independence trajectory goes on, people find that problematic, and the people who then start adopting that language are people from the Hindu right, who have a very particular conception of nationalism and national unity. The second last point is the same one that I made earlier. There are different actors who supported it over a period of time, and their espousal of the cause at particular times represents particular mobilizations which are happening in India in the broader political and sociological sphere. So it is very much a shifting terrain. And the point that I made earlier, that one mustn't make the mistake of normatively privileging one or the other. It is a contextual decision to be made when monism might serve a particular purpose, or when pluralism might be the way to go. So the last point, and I haven't dwelt on it very much, but this is really the point of having this comparative discussion. So as I said, even within constitutional law or law and religion, there's a tendency to study this without looking at the other issues that come in. I believe very strongly that the comparative element will have a lot to say about how do you understand what's sort of going on. So I've given 2 studies here, both are by political scientists which have come out more recently. So Narendra Subramaniam, a scholar based in Canada, has this very interesting book which is published in 2014, so a little before the Modi government really took charge and put in. But what he says has great significance for the way debates about nationalism are developing in India, and the Uniform Civil Code has suddenly become integral to national unity. And Subramaniam sort of points out, he studies India and 20 other countries. Many of them, as Professor Tonyati mentioned, tend to be Islamic countries. But he points out that you cannot tell which way reform will go unless you take the political circumstances into account in a range of countries, Lebanon, Morocco, Turkey. And that's also a crucial factor to assess how the reforms will go in a particular context. Iza Hassan's book came out last year, and as the title suggests, she really focuses on the colonial period and talks about the circulation of ideas. So Professor Tonyati mentioned initially, and to understand post-colonial global South nations which have experienced colonialism, it's extremely important to track this circulation of ideas. So as Hassan points out, the same people who put in place the Muslim law regime in India were posted to Malaysia, and they thought that they knew Muslims, although they were in a very different context, and then they sort of just transplanted what they'd learned earlier. And even more extraordinarily, the same process then gets transported to Egypt, which we can all admit is a very different context. So that circulation of ideas was very much happening in the colonial process, and that's important to understand what is happening in the post-colonial context. And if you want to unpack it and address the myriad issues involved, one has to pay a lot of attention to that historical context. I'll end here by just saying that the discourse about the Uniform Civil Code and personal laws in India offers insights for a comparative assessment. Perhaps not in the sense of, will India draft a model Uniform Civil Code which people can then just take and use elsewhere, but more in terms of how studying how this discourse has developed over this long period helps us understand the complex social, political, legal and constitutional issues that often intersect and need to be unpacked if one needs to understand and probably take attempts at further reform. Thank you very much.
If you don't mind, please sit there so he can show his slides.
Sure.
Yeah. Thank you very much. This was a very useful general framework of historical developments and of contemporary coordinates in which we are to locate the debate on the Uniform Civil Code. Now, I'm not certainly going to make a resume of what has been said, but I would just say that it was interesting how Professor Thiruvengadam showed us how the very idea of adopting a uniform civil code has had different purposes in different periods of time, depending on the difference of the actors that were pushing forward. So I think that's quite important, because it somehow disconnects the debate from one particular position, as one might think. Well, thank you very much again, and now let's give the floor to Domenico Francavilla, and thank you for coming to Trento.
Thank you, Roberto. Okay, thank you, Roberto, for inviting me to this timely and important workshop, and I also noticed that with pleasure that it is supported by the Jurisdiction and Pluralism Project. It was an important research project which involved us for some years. Before explaining the meanings of the title of my presentation, I would like to make some few general points that could help us to frame the most specific things that I'm going to explain, particularly with reference to the functioning of Hindu law today in India. This subject has both a very important both from a practical point of view and a theoretical point of view. Needless to say that the decisions that will be made about the Uniform Civil Code will have an impact on the lives of many people. The triple talaq was mentioned. But it's also interesting because the personal law systems in India seems to be a very fascinating experiment, a very fascinating example of legal pluralism in action. I mean that we have an example of a state legal system that actually today operates in certain matters, in family and succession laws, within a plural framework of rules, but within a rationalization that is provided by the constitutional principles. I will be back on this point later. But more generally, I want to state that we are focusing on India. We will see tomorrow some other examples in Asia. But this is obvious, but it's worth to recall it now that this tension between uniformity and diversity is actually a global issue, which perhaps, in my view at least, is essential to the dynamic dimension of law. So we have a lot of contemporary and historical example. Some historical example was mentioned by Arun, making reference to the contribution of Silvio Ferrari in an earlier workshop relating to the development of historical development of European laws, both in the civil law tradition and in the common law tradition, were could add. But I want to recall that some of the issues that we are going to analyze in these days are also present in a much closer debate we have in Europe, for instance, about the making of the European Civil Code, which is another project that seems to be very strong from a symbolic point of view and very difficult, and many critics about this issue, and on the other hand, many political forces and many scholars working on this project that now seems to be dismissed, but perhaps could be revived in the next years. Of course, the European Civil Code debate is not about pluralism meant along religious lines, but we have multiple dimensions of pluralism. And also we have multiple agencies. So whichever legal system we are going to analyze, there is this strange phenomenon of in my view, of replication of pluralism. If we consider a legal system, we can start differentiating this legal system in several different parts, in several different agents. For instance, at a certain level, the legislative, the judgment, so the judiciary, the doctrinal works, political forces. But if we focus on just one of these parts of the whole legal system, we can start again this process, and so we can find an inner plurality in each of these parts. So, as Arun also was saying, we have not just a coherent set of principles of the Supreme Court. So this plurality is replicating itself at each level. If we identify a part, a component of the whole legal system, we can then analyze that part again in terms of pluralism. But at the bottom, we have this idea of, which is very fascinating from cultural point of view, of unlimited pluralism, which is one of the tension of all discourses about pluralism and legal pluralism specifically. So if we sympathize, and I guess that most of us sympathize with the value of diversity, there is always, we can acknowledge or recognize increasingly more diversity, but there must be a point where this acknowledgement of diversity, of different principles, of different forms of life, of different rules of behaviors, at least from a state perspective, should be should stop. So in a sense, the nature of law, which is different perhaps from the nature of ethics, has in itself this idea of some binding rules, not I mean quite similar to language. So a set of rules, and which regulates interaction between people. And even if some community may be very coherent and share the same values, in each little community we can find someone who so to say agrees with that rule more than the other. So in the functioning of law, there is a level where not all views, not all perspectives, not all ideas about what is the appropriate behavior can be recognized, so, according to an idea of unlimited pluralism. So there are also, in my view, some limits of law in itself as a mean for social ordering. So there is this process from diversity to uniformity and back, because I see this as a process because new rules, new principles, new perspectives continuously arise, and there is a need, I would say an anthropological need, of making order in this disorder or new patterns of behavior, to select some rules of behavior rather than others, and to institutionalize those rules and to put them in a circuit of transmission and diffusion to other generation or to other part of society. So this process of uniformization can be seen, in my view, as a process of selection of rules. Uniformization means to choose among several rules that can, in a legitimate way, claim to be the right rule, which rules actually should be adopted and imposed on a community. So at the end of the day, the debate on the uniformization, and specifically on the Indian Uniform Civil Code, can be dealt with in a very technical way. How do you write this kind of code? But at the end of the day, the result of this debate will have this impact, this practical impact on the rights of people, on these questions. Should I do this? Do I have a right? I am entitled to. So, as Arun mentioned, the debate on the Uniform Civil Code is usually framed in terms of the Hindu-Muslim divide in India, and in terms of human rights. So there is a strong polarization historically, because for someone it is a debate about reform of modernization of Muslim rules and empowerment of Hindu and Muslim women, because belonging to Hinduism Islam or other religious communities in this very diverse, very plural India has actually important consequences in legal terms. But on the other hand, this personal law system in India is often seen as also from Western scholars as an extremely interesting experiment that could be in itself a model. So we can talk about an Indian model, a model that will have an impact in the circulation of some ideas in Asia. But according to some authors, for instance, Bernard is one among these authors, this kind of arranging diversity actually works in India, and in the long term it could also become a model for Western countries. Why not? Due to the increasing pluralization of society, of Western societies. So rather these personal law systems, rather than being somehow a backward system, something that has to be dismissed on the way of modernization, could be actually be an emerging model that has this manifestation, modern manifestation in India, and can be a model also for other very distant countries. So there are two polarized views about the functioning of the personal law system and the value and the feasibility of the uniform civil codes. This is why perhaps Arun said that until a few months ago, this debate about Article 44 was less lively, because there was, in a sense, an opinion that the systems was actually working. And as this is my last slide as an introduction, I want also to recall that we are talking about uniformity, we are talking about the Uniform Civil Code, but strictly speaking, uniformity does not imply a code. Uniformity may be reached in law in several ways through several diverse tools. Also, judgments may have this role of uniformizing a legal system as well as legal doctrine. I want to highlight that we have, to some extent, to take these two concepts as codification and uniformization as different, even though one has to admit that the codes seems to be the more effective instrument to reach in a coherent way uniformity if you have to regulate some sector of human life from a legal point of view. And in fact, this is a statement that one can find in the famous Shabano case. So it's a statement of the court that points out, in my view, the need that this uniformization should be reached through legislative instruments as the more effective instrument to reach uniformization. If we read this statement quite quickly, we can see that the common civil code, according to the judges, will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. It is the state which is charged with the duty of securing a uniform civil code. In this sense, according to the Supreme Court, the endeavor term is interpreted as a result. So the duty of securing a a uniform civil code for the citizens of the country, and it has the legislative competence to do so. A beginning has to be made if the Constitution is to have any meaning. Inevitably, the role of the reformer, I stretch, has to be assumed by the courts, because it is beyond the endurance of sensitive minds to allow injustice to be suffered when it is so palpable. So the courts actually in India have the burden to organize this, to make these personal law systems functioning in the main burden, not only the courts, but have a very prominent role, we will see. But piecemeal attempts of courts to bridge the gap between personal laws cannot take the place of a common civil code. So there is a constitutional duty in this interpretation, but as I read this passage, there is also an awareness of the fact that the civil code is the instrument to reach this uniformization, and of course explicitly a value of uniformization as a way to avoid injustice, to which the courts try with their instruments to offer remedies. This is a very famous statement, but this is, I say this in an introductory way. I want to explain the meaning of complexity in the title of this presentation, because complexity may have many meanings, but basically two meanings. One is, so to say, is the bad meaning, one is the good meaning. The good meaning is, in a sense, the philosophical concept of complexity. So the existence of several interacting parts, the emergence of something that is new from this interaction, different from the sum of these parts, and the quality of the emergence from this interaction depends on the quality and quantity of interaction between these parts. So this is a philosophical concept of the well-known theory of complexity, and in my view this would be the good meaning of complexity, because of the idea of the emergence of innovation. Innovation is not necessarily good, but there is an idea of a creative system. I don't know if the meaning of the productive potential of personal law in the contribution of Arif is this. So this idea that from several interacting laws there is something productive, something new that can emerge in terms of rights, while uniform law tends to be more conservatory. But the bad meaning, which it is the meaning actually I had in mind when I chose the topic of my presentation, is complexity simply in the sense these personal law systems is unbelievably complex, it's difficult to understand how it works, and actually judges, if you study this personal law system, its functioning in reality, one can wonder how judges are able to manage all these issues that arise in the functioning of a personal law system. And the burden, as I was saying, of the functioning of this system in some matters, of course, family and succession, is basically on the courts. And most of us know, but probably not everyone in this room, that Indian courts are secular courts, so they can apply Hindu law or Muslim's law, but the judge, the religion of the judge is not at all relevant from a state point of view. So you can have these cases of a secular state judge, which is by chance perhaps is Hindu, who is going to apply some rules in Islamic family law, or you can make all the combinations, including Christians, atheists, and so on. But the problem is that there is such a variety of rules that is, we will see better later on, that is actually can be very difficult for the judge that in some cases has to apply, for instance, some customary rules to provide a judgment. But I want to be clear on this point. The functioning of these personal law systems is complex, but I don't want to complex in the meaning of difficult. But I don't want to draw too many consequences from this difficulty. I mean, we as humans can cope with much more difficult issues. We can fight for everything in order to protect an important value. So, if the value of diversity in this context is really important, the complexity in the meaning of difficulty of working of this system is not an argument to say it's better to simplify, if on the other hand the value of diversity is perceived as really important. And perhaps it's simplistic to assume that the working of uniform and possibly codified law is easier. So even if we think of Italian civil code, etc., at a certain from a certain point of view, there are always you can have the clearest laws, codified laws, but there is law. The functioning of law is always made of complex arrangements. So let's go a little bit more in the analysis of this complexity of the functioning of personal laws. The first thing that this diversity, I will just say only this from a historical point of view, this diversity comes from the past, so as Arun well explained. And the Constitution is this founding moment of the Republic of India, and in general, not only in the case of personal laws, which was inherited from the past, had to make a lot of choice about the features of the new, the independent Indian legal system. And while making these choices, of course, there was a heated political debate, but there was also some more general phenomenon concerning all legal systems. The fact that you cannot change an entire legal system. In 1947 and later, there were courts operating. There was judgments, precedents. There was cases in the courts. So, of course, law is continuously changing, but you cannot change too radically such a all at once such a complex legal system in personal laws, but also in all parts of law. So similar debates about reforming the common law legal heritage, the British common law, the English common law heritage can be repeated for very different topics, for instance, intellectual property, patents, etc. But just to quote some relevant article, so we have this article 372, which states that all the laws in force in the territory of India immediately before the commencement of this constitution shall continue in force therein until altered or repealed or amended by competent legislator or other competent authority, and the interpretation of law in force, the official interpretation of law in force in this article is statutory law, so we will say legislation, common law in a strict sense, so we will say judgments and precedent, specified as the common law of England which had been adopted as the law of India before the Constitution, but also explicitly Hindu law, Mohammedan law, Muslim law, and customs having the force of law. So all these laws and others were operating and were acknowledged in this passage from the pre-independent period to the new period. And quite important is also the Article 13, laws inconsistent with or in derogation of fundamental rights for all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, the third part about fundamental rights, shall, to the extent of such inconsistency, be void. So this third part of the Constitution is crucial and is the filter for all the law coming from, obviously, one would say, from all the law coming from the past. And I will not enter in this constitutional debate, but of course many in that time and still now considered, and in Shabano case, in the Latifi case, consider question that the personal law systems with its inherent inequality can be constitutional compliant. So, but it's very difficult because Article 44 is a directive principle of state policy, but is in the Constitution and implicitly recognized the personal law system. So this is a strong argument for the constitutional charter of because of course can be some aspects of inequality, but the main point, if there is a legitimate ground for making a difference in legal terms, so this difference is legitimate in constitutional terms. So in this sense, we don't have differential treatment among, for instance, Hindu women and Muslim women. The Hindu Code Bill and the little acts Arun mentioned are the Hindu Marriage Act, basically, in 1955, and three other acts in 1956 on minority and guardianship, adoption, maintenance, and succession. So the mainstream view is that being possible to enact a uniform civil code in family and succession matters for all Indians, at least in the Nehru's view, one could try to simplify, codify, and reform the majority stretched Arun personal law, so Hindu law, and this was made eventually with these four pieces of legislation. And we have also several amendment laws, and in family law, which is a personal law subject, we have also some general laws, many general laws that applies actually already to all Indians, irrespective of their religious or community belonging. For instance, the Child Marriage Prohibition Act, it's one act, no? And this is wrong, Act of 2006, is clearly addressing a very sensitive topic, issue in Hindu law, but is a territorial law, so it applies, it's not applied only to Hindus, but applied to all Indians. So we have several examples of a legislative intervention in personal law subjects as family and succession, already made to uniform law. Not a code, but in some on some issues we have already uniform laws. I did not write this point here in this slide, but I want also to recall that family and succession, of course, private law matters, and a further element of relevant for the issue of uniformity is that this is a concurrent jurisdiction in the union and state relationship. So the Hindu Marriage Act and the other acts are union legislation, but we have also state legislation, state amendments that in a sense make Hindu law as applied in Gujarat different from Hindu law as applied in Kerala or in other Indian states. So this is another aspect of potential lack of uniformity. But I want to make you some examples about this, the application of Hindu law and other aspects of the functioning of Hindu law now, because one can assume that Indians renounced to uniformity for all Indians, so Muslim, Hindus, but they actually reached uniformity, at least for Hindus. And there was certainly the idea of simplify the very complex Hindu laws as applied earlier. But I want to show you that this is a very peculiar kind of uniformity, because the Hindu Marriage Act, as well as the other Hindu acts, actually, to a large extent, recognize diversity. So I want to make some examples that are also examples of the inherent complexity of the functioning of this system. For Section 2 of the Hindu Marriage Act define the application of the Hindu Marriage Act, but the same may be repeated for the other acts. And so this act applies to any person who is a Hindu by religion, in any of its forms and developments, including Virashaiva, Lingayata, or follower of the Brahma, Prarthana, or Arya Samaj. So, in a sense, when I read this article, I don't know if Arun agrees with me, but there is a certain awareness from the legislative point of view of the inner plurality of Hinduism, so in any of its forms, and the fact that the Hindu label is a way to, is quite a recent way for Indians to define themselves. Some Virashaiva Lingayatas are parts of the Indian society that may be debated if they are Hindu or not. But also to any person who is a Buddhist, Jain, or Sikh by religion. So, in a beginning in uniformizing personal law has been made because this four legislation applies not only to Hindus by religion, but also to persons belonging to other religions proper, so Buddhist, Jain, or Sikh, and to any other person domiciled in the territories to which this act extends, which is all India except Jammu, the state of Jammu and Kashmir, who is not a Muslim, Christian, Parsi, or Jew by religion. So if you are Muslim, Christian, Parsi, or Jew by religion, this act will not apply to you. If you are Hindu, of course this act applies to you, but also if you are Buddhist, Jain, or Sikh, but there are a shadow line because of this inner complexity of Indian society, because in some cases it's not so clear if a community is properly Hindu. And this may be very fascinating from the point of view of scholars of religion, but the point of view of a judge is not so fascinating, because the judge has to decide if this act applies to that specific person that has that specific marriage problem. So, in a sense, this point C is very inclusive, because you have to prove that you will not were not subject to Hindu law before the commencement of this act. And the explanation connected to Section 2 is also interesting, because Hindus, Buddhists, Jains, and Sikhs by religion may be defined. Any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jains, Sikhs by religion, any child, one of whose parents is a Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as a member of tribe, community, group, or family to which such parents belongs or belonged, and any person who is convert or reconvert to the Hindus, Buddhist, Jain, or Sikh religion. So, if you provide a legal relevance to your religious and community belongings, and I sympathize for this cultural position, you, in an event, have to solve, as a judge, a lot of additional issue in defining who is a Hindu, what happens in case of conversion, because so there is an inherent complexity of the working of these systems. But generally speaking, the logic of Hindu acts was this of simplify and reform some parts of Hindu law. So in this regard, it's interesting, Section 4 of the Hindu Marriage Act, because you can see the overriding effect of this Hindu Marriage Act. Any text, rule, or interpretation of Hindu law, or which may include also ancient treaties on Dharma, or any custom or usage as part of that law in force immediately before the commencement of this act, shall cease to have effect with respect to any matter for which provision is made in this Hindu Marriage Act. So this overriding of previous, perhaps conflicting Hindu laws, the Hindu Marriage Act tried to achieve some sort of uniformity in the very complex pre-existing Hindu law, at least in what is in the subject of Hindu Marriage Act and other Hindu acts. So, but which is the way to achieve this uniformity? Actually, uniformity may be reached generalizing the rules of a part of the Hindu society, of the Hindu communities, making them general. Apply. So, for instance, in the troublesome case of child marriages, not all Hindus married or marrying themselves at a very early age. In some communities, this was a diffuse practice. In much more communities, this was not a diffuse practice. When the law uniformized a rule about the age of marriage or about polygamy or monogamy in the Hindu context, it is actually deciding that one of the rules followed by the several Hindu communities is the Hindu general rules. So for some Hindus, the legislative intervention will make no difference, because they were in any event following that rule that the legislation chose as the best rule. For other communities, for instance, for important Hindu communities that are that follow polygamy rather than monogamy, that is majoritarian, monogamy is majoritarian in Hinduism, the difference is crucial. So this is the uniformization is a process partly of generalization of existing rules in the Hindu context that becomes general for all Hindus. But in doing so, in any event, the Hindu Marriage Act tried to preserve, perhaps this may be seen as compromise and negotiation, as Arun was telling, of diversity, through, sorry for some typos, acknowledgement of customs, but in some cases. A few examples. The most famous example is section 7, about the solemnization of marriages. In this case, we have a full acknowledgement of the very different ritual and customs of the different parts of Hinduism. You can say, okay, but solemnization of marriage is not so sensitive. If they want to marry in this way, it's okay. If they want to marry in the other way, it's okay as well. But the solemnization of marriage, the existence of the marriage, actually is a very complex issue. And there are a lot of Indian judgments agonizing about. There was actually a Hindu marriage. Was the appropriate ritual followed in that case? And this may have an impact. The existence of marriage may have an impact in all family, potentially in all marriage issues. But there was a sense that this diversity should be preserved therefore, a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. And there is this problematic second part, where such rites and ceremonies include the saptapadi, it is the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire. The marriage becomes complete and binding when the 7th step is taken. Saptapadi is, one could say, the most prestigious form of celebration, but never was the only forms of celebration. And it's difficult. I will not enter in details, but in the several judgments there are discussion about this issue that may seem pacific, but according to some judges, saptapadi is the proper way for all Hindus. So there is also a process, so to say, of Sanskritization inside the judiciary, depending on the bias of judges. In this section 7 is here an example of this full acknowledgement of how many. I didn't know this. How much time do I have?
Well, effective 5 minutes over.
Ah, sorry.
Yeah.
I totally.
How long do you need?
I thought that I began 5 minutes ago.
No. You had already 40 minutes.
But I'm going to.
In fact, 45. Yes.
Okay, so I will go. So these are examples. So there is an acknowledgement of customary divorce, an acknowledgement of the customary usage in a kinship relation, for instance. So there are very techniques, full acknowledgement, general rule which admit exceptions, etc. So there is this picking some elements of diversity, and custom may be applied. But this is important. Indian judge may apply today perhaps a very ancient Hindu custom, but only if this is coherent with public policy, so with constitution. This is important. I want to stress this because Hindu law is an official part of, as well as Muslim law, Christian law, are official parts of the Indian legal system today. But in this manifestation, they interact with the constitutional principles, and according to some authors, this is a way to promote their, to acknowledge them, but at the same time to put them in the path of the constitutional principles. I will skip the baby case, which was an example of the complexity of application of these rules in context. I will just make a reference to the issue of conversion, because we have some important Supreme Court case, Thomas case of the 2000, a Law Commission report of 2009, if I'm not wrong. The problem is what happens if a Hindu man who is married with a Hindu woman converts himself to Muslim law. Can he marry again? Because polygamy, of course, is not diffused, but is allowed for Muslim, but is not allowed for Muslims. So the view is that he cannot. So the eventual view is that he cannot. If he married under the Hindu Marriage Act, he cannot escape from these Hindu rules by converting to Muslim law. And these are the recommendations, but I skipped them because I arrived to the conclusion. But the good sense of complexity is this idea of interaction, several orders, and interaction is a way to taking things together. So this view of Meskin and others is that this plurality in the Indian context, in any event, is taken together, and this is a positive fact, because the other view is that there is a risk of splitting of legal orders, because we have also always this potential divide between the official state law and the Uniform Civil Code will be the most prominent example of this official state law equal and uniform, but this way to proceed, state-led way of proceed to uniformization could produce a separation, an increasing of unofficial law, of laws and rules that are followed by communities in the shadow of official law. So they will not go to the courts, and they will not put themselves under constitutional principles, because they will not feel acknowledged as Muslims and as Hindus. But this is very, very complex issues. The last thing I will say, and that I have no idea of what kind of legislative technique could be used to draft this uniform civil code, because it's very difficult also from a technical point of view. All important codes in the history of law have had important doctrinal works at the basis of the codes, in the making and after in the interpretation of those codes. But the Hindu Marriage Act style of uniformity, as you can see, is not actually uniform in the sense in which we mean uniformity, because we have all this, actually we have a lot of Hindu laws depending on customs, etc. There is a certain sense of uniformity, but not properly a uniform Hindu laws. So I must say that some years ago I was all in favor of the personal law systems, all against the Uniform Civil Code. Quite recently I am a little bit more confused actually. But just today I thought, so this is not, it's just an idea, very fresh, but what about an Indian marriage act, Indian, not Hindu, not Muslim, or if you want an Indian civil code in feminine succession matters, but framed in a Hindu marriage act style. So putting all these personal laws, Hindu, Muslim, Christians, Parsi, Jewish, together. This can, but allowing some space for diversity. This is not necessarily a good idea, but in any event we'll have at least one advantage, that from a symbolic point of view you will have not Hindu law, Muslim law, but Indian law, acknowledging inner diversity of the Indian society. And from a technical point of view, you will have all these rules, including also territorial rules, in the same text. If you like the idea of a code as a text where interpretation, a coherent text where interpretation may exercise itself, the idea of having this point of reference could perhaps helps a further elaboration of this law. So I'm sorry for going so long in my presentation. Thank you.
Indeed, it was and it is very interesting, and I'm sure that many issues that were raised during your presentation will be part of the discussion. But I do have to enforce the rules. Yeah, yes. And so one of the rules is that we have now a right to a short break, and such right will be exercised by not only by having a break, but having a coffee during the break, for whoever wants to have a coffee or a tea or a drink. But then you have to go upstairs and make sure that you'll be back I would say, not later than 15 minutes, please. Otherwise, we won't have enough time for a rich debate as the presentations deserve, of course, after the starting remarks by Carol Appi. Okay, so 15 minutes from now, go.